So the European Quantum Industry Consortium was set up about 5 years ago, if I remember rightly, by a lot of companies that were involved in the quantum flagship this is the research program supported by the European Union. And what we're really trying to do now is to continue to encourage the development of research and technology, but more importantly, the commercialization of quantum technologies. We recently, for example, had a fantastic webinar on valorization, commercialization of intellectual property with some of the leading experts on this subject from Europe, and explaining how they had done it in other companies and how they were intending to apply their approach in the quantum technologies. We have looking at a number of application fields, so we have a number of companies that are really interested in potential applications, whether that's in the field of logistics, medical devices, sensing, design of molecules, more importantly, the travelling salesperson's problem. These are really some of the areas that we're looking at. We have a conference about twice a year where we exchange information, where we get to meet each other, and from that collaborations develop. But one of the other things we're also doing is we're developing lots of input to the European Union, to the European Commission, how industry sees the development of quantum technology. So, for example, we've made submissions on the Innovation Act, we've made submissions on the forthcoming Quantum Act, and we'll continue to do this over the next few years. It's always a very big question. It's one of the questions we'll often be asked by companies that are interested in filing patents. Well, it's going to take 2 or 3 years, maybe even 4 or 5 years for the patent to be granted. To which I often respond, well, actually, you can get patents granted much more quickly at the European Patent Office if you request accelerated examination. I've been able to get patents granted in less than 18 months. Obviously, a couple of special cases, but we can actually move on that. Getting patents on the basic technology, the foundations of quantum science, that is the most important thing. And there's some really great patents filed by research organizations, but also filed by commercial companies out there on some of the basic physics of quantum technology. And those patents are going to be valid for probably the next 20 years. So it's worthwhile even thinking about that. For the more narrower patents, the application patents, that obviously then becomes a balance. Do you spend quite large sums of money filing the patent application, or is it better just to get your product out there as quickly as possible? Those are some of the challenges I think everybody faces within the patent process. And we try and work with companies in order to explain to them, the cost-benefit aspect of patenting, but also to think about some of those pinch points that everybody is going to need within the quantum field. That means that those patents, even if they're very narrow patents, can actually become some of the most valuable patents that you have. Well, it's very true that trade secrets are often used in the quantum sector, particularly for manufacture, fabrication of chips and devices, because you cannot see outside of the fab how these devices are being made. And we know that from semiconductor physics. Most of the major foundries have a very limited patent portfolio and often do not teach us in the patent documents how they're actually really manufacturing the chips. They'll teach us the design of the chips, they'll teach us how you can theoretically manufacture it, but some of those very important internal points which you would only know if you were working in the fab are never actually patented at all or written down in patent applications. When we come to designs, chip designs, then it's probably more important to think about patenting those designs because they can easily be reworked, reverse engineers. There are companies that will actually do that for you in order to determine, for example, infringements of patents or to find out how the competitors are actually working in various fields. But I do think about sometimes with trade secrets, people say, okay, we'll use trade secrets instead of patenting, and forget, however, that a trade secret only remains a trade secret whilst it's secret. The moment that chip is delivered out into the client base, then it may longer be considered a trade secret. Open source is a very interesting concept, and we've discussed extensively open source and the relationship between open source and patenting. Yes, within Europe we are encouraging open source, a free exchange of ideas, but that does not necessarily mean that you should not patent those ideas, because even if you consider your ideas to be open source, even if you consider your ideas to be able to be used by everybody else, that may not be the case in other countries, with other companies, with your competitors. So we see that sometimes, well, I said, we've seen companies say in other fields, I've put this out in open source, for example. Yes, that's fine. You've basically given a license to use your technology, but you still need a license to use somebody else's technology. And if you've not got that protection in place, you cannot do this cross-licensing aspect to it, which is very, very important in ICT technologies. Yes, it's this complementary asset and understanding how you are going to commercialize, valorize your intellectual property. Is your aim to be able to exchange ideas, to be able to cross-license with each other, to get standardized technology, or maybe you have to do it in order to be able to sell your commercial products? What is going to be your crown jewels which you do not want to license out, which is really going to add a lot of value to your company? Those are some of the considerations that I think companies really need to understand in the quantum space, as they do in other spaces it should be added.